Hey folks, Chris from Prep Logic. Today we're continuing our videos on the Constitution and the Bill of Rights with the Sixth Amendment. Hey folks, we're discussing the Sixth Amendment today. Now the Sixth Amendment reads, in all criminal prosecution, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime has been committed, which district shall have been previously ascertained by law, and to be informed of the nature of the cause of the accusation, to be confronted with the witnesses against them, to have compulsory process for obtaining witnesses in their favor, and to have the assistance of counsel for their defense. I did use some general neutral terminology just for civility's sake. So we're going to go over what the Sixth Amendment guarantees, which is basically your right to a speedy and fair trial, and how infringement can be determined on these bases. So there are guidelines for determining if your right to a speedy trial has been infringed against. Those guidelines are the time span of the delay, the reason for the delay, and whether or not the defendant has complained about it. So the court can't take 2 years to try you for something. They can't have a time period where the diminishment of evidence can take place. If they do, they have to give a reason for that delay. And the courts have to decide whether that reason is reasonable. And if you, as a defendant, don't complain about it, it's kind of like this weird, you don't point out there wasn't a wrong thing. So going forward, you have the right to a public trial. Now, the Supreme Court has said that both parties in the case do have the right to say that people can be barred from the courtroom if their presence is going to hamper the judicial process, or the plaintiff or defendant requests it, in other words. You have the right to an impartial jury. Both legal teams get to be involved in the jury process. They ask questions to basically determine whether there's any prejudice towards your case. And if those people do have prejudice, they're barred from the jury. That way you're guaranteed a fair trial. You're guaranteed a notice of charges. And what that means is the judge is going to tell you what you're being charged with in court. In the case of a felony, this is called an indictment and is generally done before a grand jury. But occasionally it's done in court. You're guaranteed the right to question your witnesses and the witnesses against you. You're also guaranteed the right upon discovery to subpoena further witnesses. Now, to help you with all these processes, you're also guaranteed an attorney. However, the misconception is that once you're arrested, you're immediately provided with an attorney. This isn't always the case. Technically, until you have been read your charges, you're not charged. And the court doesn't have to necessarily provide you with an attorney. In the case of many states, they automatically do, just because. And of course, to help you navigate through all this, there's some basic legal representation at the time of your arrest. And you also always, if you're anticipating you're going to be arrested, you also have the option of keeping an attorney on retainer. Now, for the most part, there hasn't been a lot of infringement against this amendment, but the infringement there has been severe. The two most notable cases are pretty famous. and kind of in the news right now because of the date and the anniversaries of them. The first one would be the case against Randy Weaver. He was purposely given wrong information about his court dates and denied his ability to do all these things. Simple as that. The second would be the case of the Branch Davidians. And this one is really, it's just out there. So the U.S. District Judge, Walter Smith, personally decided the initial jury panel of 84. He did this by selecting them out of a jury wheel of 300 potential jurors, and he based his selections entirely on answers supplied by the potential jurors to a lengthy questionnaire concerning their attitudes toward gun control, religion, and government and federal agencies. Judge Smith overruled separate trials for several of the defendants. That increased the chance of conflicting and therefore ineffectual defenses. Almost half of the subpoena for witnesses requested by the defense were refused by the court, some on the flimsiest grounds or no grounds at all. Finally, throughout the evidentiary portion of the trial, the court refused to permit any direct or indirect hint of the issue of self-defense on the Davidians' behalf. Neither in cross-examination of prosecution witness nor in testimony or other evidence put on by the defense. The judge regularly sustained prosecution objections whether defense questions could be interpreted as leading toward the governmental misconduct or not. He also refused to let the Davidians or their attorneys ask any questions but questions that pertained to the first day and the last day of the siege. They weren't allowed to refer to the sniper tower as anything but the water tower. The trial was a farce. They were denied all of those rights I just read you. And as I said in the previous video, if there's one instance of infringement, there's a problem. Here we see two right here. So, clearly, our justice system has some issues to work out. And there needs to be some reform. I'm not sure it's at the lower levels of the justice system, but definitely in the judiciary level of the justice system. As always, folks, be decent to each other, because we're all in this together. God bless.
We want to thank you so much for listening this week, folks. If you like this content, hit that like button and subscribe. Leave us a comment, let you know what you think, and share this content across social media. As always, folks, be decent to each other, because we're all in this together. God bless.